Welcome to the Border Criminology's video series on key concepts in the border criminology's field. Before we begin, I would like to acknowledge that we are both on the stolen, unceded lands of the Vogl people and pay my respects to their elders past, present and emerging. My name is Anthea Vogl and it's my absolute pleasure to have with me here Associate Professor Maria Giannacopoulos to speak about decolonising approaches to migration and refugee studies. Today, we are discussing Maria's research published as Nomicide, or the Non-Performativity of Colonial Law. The piece was published in the 2022 edited collection, Performance, Resistance and Refugees, a link to which will be available in the comments. But before we begin, I'll ask Maria to briefly introduce yourself.
Thanks, Anthea. So as Anthea has mentioned, I'm an Associate Professor of Criminology at the University of New South Wales here in Sydney on Vogl land, Indigenous land where sovereignty and law were never ceded. I have a background, not in criminology though, I have a background in law and cultural studies, cultural theory, and I now work in a criminology team, but am still quite connected to thinking through questions of sovereignty, questions of borders, in particular around the work that law does in producing borders and what I think through as law's violence. That's the kind of work I do. I was born and raised in Sydney on Gadigal land. I have migrant parents. This is something you can read about in the article as well. I say a little bit about my background there. So yeah,
great. We'll jump in.
Go for it, yes.
Maria, can you talk a little bit about the main ideas you're pursuing in the chapter and also how the chapter works with or fits within your broader work on what you call the nomopoly of the colonial legal order in Australia?
Yes, I'd love to do that. It gives me a chance to think through the various connections and the various concepts that I've been working on creating in the last few years to help us to think through law. So law is the main kind of fixation in my work. But when I say law, really what I'm referring, because I work in the Australian context, and the Australian context is a settler colonial context, when I say law or when others say law, what we really are saying is colonial law. But this is something that gets effaced or kind of not, so it's something that is not so visible in discussions of law, in discussions of borders, in discussions of sovereignty. So I've coined this concept of the nomopoly. So here I do draw on my Greek background. So nomos meaning law and poly means the monopoly of. So I'm trying here to capture this idea of, so this is the kind of broader framework, and then I'll return to what the chapter is doing. But so that in a settler colonial context where law is imposed by the colonizer as a legal infrastructure, it is taking over and usurping the space of what can count as law. So it's a monopoly of law in a place where law and sovereignty pre-existed. So that's the concept of the nomopoly. In this particular chapter, I look at other concepts and related concepts to the nomopoly. In particular, I coined the concept of nomicide in this chapter, and I link that to the idea of non-performativity. So I borrow here from Sara Ahmed's work to think about non-performativity as, you know, something is being done, something is being said to be done, but it's not. So what is being done by law in this example is not the thing that it says it's doing. So what I'm trying to capture here is that in a settler colonial context, law says it is about peace, order, good governance, etc. But that is not actually what it's doing. It is generating nomicide or legal death. So that means that when Indigenous law is effaced, that's a kind of death. When people die at the hands of colonial law, in particular Aboriginal people, that's a form of nomicide. When land and country and waters are controlled not by Indigenous people, that's also a form of death that is enabled by the law. So this is the non-performativity idea. And the other idea, I guess, is integration, as an idea about integration. And I guess what I'm starting to do in the introduction is to show how I myself, as a person born to migrant parents, who is a white person in this country, but still a racialized person, what is required in the settler colonial context is an integration to a particular idea of law and nation. But then I don't know that I do it completely in this chapter, but what I am getting at with the idea of nomopoly is that nomopoly, or the sort of centering of the colonial law, requires a kind of legal integration. So I might leave it there for that question.
No, it's great. And I think we'll come back to the kind of question of integration when we are talking a little bit more about some of the decolonising approaches to migration and refugee studies, which is actually where I was heading next. Great. So I know it is really difficult to summarise, and it's a big field, but when you talk about decolonising practice or approaches to migration and refugee scholarship and the importance of centering them, what does that involve? Or specifically, what are you thinking about as encompassing that decolonising practice? And I just wanted to include your own quote from the article, which gives a bit of a sense of some of your framing here, where you say that we, as knowledge producers across a range of disciplines, but especially in refugee and migration studies, cannot produce knowledge as though the grounds upon which we create knowledge are empty of Indigenous sovereignty and law.
Yeah, look, it's a big one.
It is. And it's a mean question to ask you to summarise.
Yeah, but it is a good one, and it is something that I think that I would like to explore further, because I think that what you can see when you read the chapter is that I've built to making that argument, but there is a lot to be done further in sort of teasing that out. But I guess, so as someone who works on thinking about law in a range of contexts, including in refugee migration studies, when I focus, say, specifically on looking at work in refugee migration studies, you know, I can't help but notice that what is happening is a dialogue between migration scholars, especially those of us who are seeking to support and advance the rights of migrants and refugees. There is a kind of dialogue going on between that scholarship, that sort of activist work, and the state and its laws. And so, and I guess that I'm doing something that is just trying to show that we can't, you know, so we often in Australia, for those who are very familiar with the Australian context, will know that you can't attend an event at a university without hearing often the acknowledgement that sovereignty was never ceded. But I think that what is missing in that story or in that narrative is that if sovereignty was never ceded, law was also never ceded. And so when we as migration and refugee studies scholars speak about, you know, improving the rights of migrants and refugees, we have to make visible that the dialogue that we're having is with an authority that doesn't have authority for its authority. So that gives a further and huge conundrum for us to deal with. But if we don't do that, if we don't sort of, you know, allow that to become visible in our work, then we kind of run the danger of reproducing that logic of emptiness. And that logic of emptiness is that, you know, that the place that came to be known as Australia, where colonial law now kind of reigns over the place, is empty of other laws that can make decisions about hospitality, who it's offered to, who can live here, under what conditions. So I think that is what I'm saying about knowledge production in these areas has to be kind of mindful of the sort of larger role of what colonial law is and how it relates to migration and refugee scholarship.
Yeah, and you can see really clearly in this chapter the ways in which those arguments extend to affirming and reinscribing state or colonial sovereignty when exactly the discussions that you're talking about are left out. of the ways in which we make claims or make arguments as kind of migrant and refugee scholars.
And I think it's a very complex space because, you know, there has to be a space to be making those arguments. This is not about saying that we can't be making those arguments. But if part of our kind of role or vision is to try to connect the questions that give rise to suffering of, say, people who don't have their rights supported or can't have them realised, and, you know, the kind of broader suffering that comes from the imposition of a colonial structure, if we're not connecting those things, then we're not, you know, I guess we're not seeing the bigger picture and the interconnectedness of the issues and problems.
Great. And that's probably a nice lead into the next question, which is a question about the broader theoretical work that this chapter and also your work in this area, which has been sustained, is in conversation with.
Yes, I do like to have a conversation with myself in the
not your part work, but sure.
Yeah, look, so the chapter starts with the quotes by Professor Irene Watson, and her work has been instrumental in allowing me to see and understand law as colonial law. And in particular, I mean, she wrote, one of the quotes was from many years ago, but was talking about the way in which it was able to be seen through the, you know, the kind of in a national conversation that there was, you know, detention of refugees and that this was a problem. But the deeper issues of detention of Aboriginal children, for example, was still something that was not making the national radar. And she's saying, you know, why is one thing visible and not the other? And I guess that, you know, her work helps me to connect some of these dots about the questions actually being quite interconnected. So I also use the work of Professor Joseph Pugliese and Professor Suvendrini Perera, who worked for many years on the Deathscapes project, and that was a project committed to ending deaths in custody and looking again at the related nature of Indigenous incarceration and carcerality in relation to colonised societies and what happens at the border with refugees. So that project has been a really important one for me to connect to and with my work. And then, you know, most obviously in this chapter is the work of Sara Ahmed, who, you know, offers this notion of non-performativity, which I think is a really helpful way to rethink. You know, I mean, some people don't need to rethink it. Some people get it instinctually. You know, the thing about law and law's violence, I mean, that kind of point for some will be really obvious. Like if you are a target of the carceral system in Australia, what I'm saying will be of no surprise. Where it may be of surprise is where people haven't experienced the brutality and the punishing nature of colonial law. So that's, I guess, where I'm seeking to use Ahmed to help sort of reframe law in a theoretically different way.
Yeah, great. And to kind of pull apart law's performance as not to be taken on its face, which, as you say, instinctively you know, but to kind of see it as explicitly non-performative, I think is a really important point.
That's right. And I mean, I guess just to say a little bit there that, you know, many people would be familiar with the Mabo decision, which, you know, has been considered and spoken about explicitly as a landmark decision. And that was the case where the concept of terra nullius, which told us that Australia was empty and that's why the colonial system could be imposed because there was no one here. So that was initially a lie. And then we're told in 92 that that was overturned. So this is the performative nature of what law is telling us about the law, that it's been overturned. But that case does a lot of things, but what it doesn't do is overturn who owns the place and how the land is still treated as empty of Indigenous law.
Yes.
So that's where Ahmed has been super helpful.
Great. And a last question, which is something of a broadening out maybe, but your research and your writing and your work are very much grounded in and informed by your experience, your history, and your own engagements with law and the world around you. Has there been a moment or a project or a particular experience that's had an impact on you, or that's been memorable or significant as you continue to undertake work in this field?
I think so many moments. And so, but, you know, I do speak in the chapter about sort of rethinking my early university life. And so maybe I'll speak a little bit about that, and, you know, engaging in the university and reading, you know, in the course of my arts degree about migration and how it came to be, and sort of seeing yourself presented. So, you know, I mean, I guess I remain fascinated by the fact that, you know, I'm not a nationalistic Greek, but I have a Greek background. Greeks are supposed to be white. But this, of course, was not something that the colonial state saw as a truth, whatever that is, until the 1950s, where they shifted. And so the discourse at the time was that, you know, it's okay, we can let the Greeks in, Greeks and others like the Greeks, because eventually they will be indistinguishable from British stock. So this is the idea about the violence of integration. And so for belonging as a migrant, or, you know, the child or grandchild or great-grandchild of migrants, is that you will be erased of your origins, and that is the kind of precondition for your inclusion. And so thinking about that has I think it's also really important, and something that, again, I've started to do in this chapter, but I'd like to do more of, is to situate, is to kind of make visible the place from where I see things about law the way I see them. And I think that is from the grounded experience, you know, of being a white person, but a racialized person within the colonial state. And, you know, and I must say that this is also, you know, something that, you know, universities are not places that are easy to negotiate when one sees the world in these ways. So, you know, so it's very interesting that the university kind of features as this, you know, place of empowerment, but also a place of, of kind of disciplining of knowledge and knowledge production.
Great. Thank you so much, Maria.
Thank you. It was lovely.
Yeah, it's been
chat.
Really lovely to chat, and I really appreciate your time.
Thank you.
I will speak to you soon.
Definitely.